Having concluded part 1, let's now take on part 2. Sources of the law and rules guiding Nigerian criminal litigation. We will cover a total of 4 subtopics: an overview of the sources, what laws and rules operate in various parts of Nigeria, what laws and rules operate in various courts in Nigeria, and finally, there will be a take-home assignment involving comparative and comparison the laws and rules operating in various courts in Nigeria. Let's take on the first part, an overview of the 3 types of sources. The rules or laws applicable depend on the following factors. The first factor is the type of court. Is it a magistrate court? Is it a state court? Is it a federal high court? Is it a court of appeal? Or is it the Supreme Court? The second factor is whether or not the state has investigated the ACJA, as short for Administrative Criminal Justice Act, and if it has not, then whether the state is in northern Nigeria or southern Nigeria. The third factor is whether or not an appeal exists in the law applicable to a particular jurisdiction and the express provisions of the law in such circumstances. With that at the back of your mind, let's now take a look at the sources, the high level overview of the 3 sources that you will be considering. You can see them shown on the screen: principal sources, secondary sources, as well as tertiary sources. Let's take the first principal source, the ACJA. ACJA is short for Administrative and Criminal Justice Act 2018. Before the ACJA came into force, the major procedural criminal law for Nigeria became either the Criminal Procedure Act (CPCL) or the Criminal Procedure Code (CPCL). Legislation enforced in Nigeria determined whether Nigerians speak along Nigeria's northern or southern region. For northern Nigerian states, the CPCL carries sway. For southern Nigerian states, the CPCL reigns. Since 2015, the principal statute applicable to the High Court of the Executive, all other federal courts, and any state high court that tries a federal offense is the ACJA. Please refer to section 2, subsection 1 of the ACJA. The next principal source is the Administration of Criminal Justice Law, ACJL. If a state domesticates the ACJL, it becomes known as the ACJL. A total of 24 states out of Nigeria's 36 states are down this. They include Anambra State, Cross River State, Delta State, Ekiti State, Enugu State, Kogi, Lagos State, Ondo State, Oyo State, Kaduna, Rivers State, Akwa Ibom State, Edo State, Ogun State, Plateau State, Osun State, Kwara State, Adamawa State, Ayelsa State, Kano State, Jigawa State, Abia State, Benue State, and National. Our third source is the Criminal Procedure Code Law. The history of the Criminal Procedure Code in Northern Nigeria is traced in the then Chief Justice of Nigeria, H.C. Bolan's Criminal Procedure Proclamation in 1903, which was based on the Gold Coast Criminal Procedure Ordinance of 1876. Following the amalgamation of Northern and Southern Nigeria, Governor General of Nigeria sought to unify the criminal procedure laws of both regions through a consolidated ordinance known as the Nigerian Criminal Procedure Ordinance of 1904. So for a period of time, all of Nigeria had one criminal procedure law. And subsequently, the Criminal Procedure Code was passed into law by the Northern Regional Government in 1960. Northern states later domesticated it when we have CPCL, the short of Criminal Procedure Code Law, as a state law. This has the effect of making the CPCL the principal criminal procedural law applicable in those territories until the ACJA was integrated to become the ACJL in those states. States which still use the CPCL include Bauchi, which is actually attempting to domesticate the ACJA at this moment, Sokoto, Kebbi, Niger State, Zamfara State, Katsina State, Yobe State, Borno State, Gombe State, and Taraba State. Criminal Procedure Law. The history of the Criminal Procedure Law in southern Nigeria is traced back to the Gold Coast Criminal Procedure Ordinance of 1926, which was originally enacted in Lagos as part of the colony of Gold Coast. Following the amalgamation of northern and southern Nigeria, Governor General of Nigeria sought to unify the criminal procedure laws of both regions through a consolidated ordinance under the Nigerian Criminal Procedure Ordinance of 1914. This law was subsequently revised, and this led to the passage of the Criminal Procedure Act in 1945 that applied all of Nigeria. However, due to its incompatibility with the mode of life and religion of northern Nigeria, in 1967, the scope of application was restricted to southern Nigeria. Southern Nigerian states then domesticated that it became the CPL, that's at the state level, instead of the CPA, which applies at the federal level. By virtue of the now repealed Section 3 of the Federal High Court Act, the CPA used to apply the proceedings of the Federal High Court and made it up margins. The C Section 493 of the ACJA which repealed the CPA, making the ACJA the current superior criminal legislation in force of the Federal High Court and indeed all federal courts. That brings us to the end of principal sources of criminal law and criminal legislation. Our first secondary source is the 1989. The reason why it's called the secondary source is that these are sources that, although they may contain some provisions on criminal litigation, that is not their whole or sole purpose. Let's take on the 1999 Constitution of Nigeria as amended. It feels rather strange that the Constitution, either with one law or rule, that said that the foundation of the legal system can be called the secondary source of law. Notwithstanding, the Constitution has a number of provisions that deal with criminal litigation, including but not limited to the cumulative terms on the ground of Section 1, Subsection 1 and 2, the right to life in China, Section 23, the right to personal liberty, Section 55, the right to fair hearing, Section 56, knowledge prosecution, Section 174, Subsection 1, Section 211, Subsection 1, the prerogative of mercy, Section 175, Subsection 1, and 212, Subsection 1, as well as the jurisdiction of criminal courts. Our next source is Criminal Code Act or Criminal Code Law. The Criminal Code Act and its state-level equivalent, known as the Criminal Code Laws of the respective states, as the case may be, constitutes southern Nigeria's substantive criminal law that defines crimes and basically criminalizes offenses considered to be improper conduct. Southern Nigeria. Our next secondary source is the Penal Code Act or Penal Code Laws. This is Northern Nigeria's equivalent of the Criminal Code Act. According to the book, The Penal Code of Northern Nigeria and the Sudan by another book, and article. The Penal Code Act in use in Northern Nigeria was enacted in 1959, but it came into effect in 1960. It was based on the Penal Code of the Sudan, enacted in 1890, which in turn is based on the Indian Penal Code drafted by Lord Macaulay between 1833 and 1857, and brought into force in 1860. Until then, substantive criminal law in Northern Nigeria was based on the Nigerian Criminal Code of 1960, promulgated by Lord Macaulay following the amalgamation. The Penal Code Act provided offenses considered to be improper conduct in Northern Nigeria. Our next secondary source is the Evidence Act. The law of evidence is relevant to criminal litigation because it governs how both sides will divide the prosecution will defend to prove the facts they intend to rely on with the course of the criminal proceeding. It deals with the quantity, quality, and even the type of proof necessary to establish one's version of events in court. With respect to criminal litigation, the standard of evidence required of the prosecution is evident beyond all reasonable doubt, unlike in civil litigation where the standard of evidence required of the claimant to succeed, which is a preponderance of evidence. Our next type of is known as secondary acts, or secondary enactments. These will include the Police Act, the Armed Forces Disciplinary Proceedings Special Provisions Act, Coroner's Act and Coroner's Laws of the respective states, Children and Young Persons Act and laws of the respective states, Supreme Court Act and Supreme Court rules, Court of Appeal Act and Court of Appeal rules, Federal High Court Act and Federal High Court rules, High Court laws as well as magistrate court laws. The list continues to include the Independent Corrupt Practices and Other Related Offences Act, the Bankruptcy Fraud and Other Fraud Related Offences Act, the Donor Trade Offences Act, Recovery of Public Property Special Provisions Act, Firearms Act, Robbery and Firearms Special Provisions Act, Public Order Act, Terrorism Prevention Act, Money Laundering Prohibition Act, as well as the Money Laundering Prohibition Amendment Act, Cyber Crimes Prohibition and Prevention Acts. With that, we have concluded with the secondary sources. We now move on to tertiary sources. What do you mean by tertiary source? English, procedure, and structure. The Nigerian Criminal Procedure Law spells to make provision for the procedure for handling a certain type of criminal matter, or the Nigerian Criminal Procedure Laws make provision for the procedure for handling a certain type of criminal matter, it fails to state the conditions for applying such provisions, then, in the first scenario, if the jurisdiction is the southern Nigerian state that has not domesticated the ACJA, then section 363 of the CPCL shall apply which states that the procedure and practice for the time being involved of the High Court of Justice in England in criminal trials shall apply to trials in the High Court insofar as this Act has not specifically made provision then. Scenario 2. If the jurisdiction is Lagos, then section 266 of the ACJL applies, which states that the court shall adopt such procedures as will in its view give substantial justice between the parties. Scenario 3. If the jurisdiction is the FCT of federal courts, wherever situated, then section 492 section 3 of the ACJL applies, which states where there are no express provisions in this Act, the court will apply any procedure that will meet the justice of its. Scenario number 4. If the jurisdiction is a northern Nigerian state that has not domesticated the ACJA, then the CPCL applies in section 35 of the High Court Laws of Northern Nigeria indicates that the reception of and reliance on any rules of practice and procedure is expressly forbidden. In practice, northern courts will review what determines what constitutes substantial justice to the parties involved. There's a case related to this, as charges in the state in the 1981 case, where it was held that a bail application in the High Court, in the absence of particular directions, was by summons or by motion. Like in the South, where a bail application is by summons. So, an alternative classification scheme is hereby proposed. In this classification scheme, there are basically two types of law. There is substantive law and there is procedural law. Substantive criminal law defines crimes and punishments. Procedural criminal law is the set of procedures for making criminal law via precedents, administering criminal law as codified in statutes, as well as enforcing criminal law. To better understand this classification scheme, let's study the history of criminal legislation in Nigeria. Basically, The English handed over to Nigeria two kinds of criminal legislation: substantive criminal legislation and procedural criminal legislation. Let's take a look at the substantive criminal legislation first. First of all, we have the Criminal Code of Northern Nigeria of 1904 for the North. Unfortunately, there was no equivalent for the South. Not until following amalgamation, when Lord Lugard passed into law the Nigerian Criminal Code of 1916 for all of Nigeria, that's both the Northern Nigeria and Southern Nigeria. Following independence, we then have the Northern Nigerian Penal Code of 1960, or the Penal Code for short, and then Southern Nigeria had the Criminal Code Act. We are now done with substantive criminal legislation. Moving on to the procedural criminal legislation. It all began with the Criminal Procedure Ordinance of 1876, which was enacted in 1903 in the South, and H.C. Goland's Criminal Procedure Proclamation of 1903 in the North. Following the amalgamation, we had a consolidating ordinance known as the Nigerian Criminal Procedure Ordinance of 1914. Subsequently, Northern Nigeria adopted the Criminal Procedure Code, while Southern Nigeria went with the Criminal Procedure Act. Now we have the ACJA for all of Nigeria at the federal level and for the FCT, and the ACJL at the state level for states that have domesticated the federal legislation. However, since not all states have domesticated it, some states still have procedural laws based off. And what I mean by based off is that those laws are reenactments of the CPC or the CPL, depending of course on whether the state is in the north or the state is in the south. You may have observed that we have included the Evidence Act under procedural criminal legislation. And that's because Merriam-Webster's dictionary defines adjectival law as the portion of the law that deals with the rules of procedure governing evidence, pleadings, and practice. According to another legal source which we consulted, adjectival law pertains to and prescribes the practice, the method, the procedure, or legal machinery by which substantive law is enforced or made effective. In short, it prescribes the procedure for obtaining a decision according to substantive law. Modern jurists now prefer to use the term procedural law instead of adjectival law. So that's the relationship between adjectival law and procedural law. Just as adjectives describe or modify nouns or pronouns, adjectival law modifies how substantive law is enforced or made effective. In fact, the role that the Evidence Act plays is trying to create a level playing ground for the prosecution and the defense in the criminal case. So it amends the procedure or affects the procedure. Our third source is English procedural criminal legislation. We already treated this when we treated the other classification type. So whatever we said there applies here with equal force. It's just that this is a different way of looking at the classification of the sources of criminal litigation. Let's take a look at the laws and rules applicable to criminal litigation in the various parts of Nigeria. In northern Nigeria, we have the 1999 Constitution as amended, the Administration of Criminal Justice Law (ACJL) if the ACJA has been domesticated, or the Criminal Procedure Code Law (CPCL) if the ACJA hasn't been domesticated, the procedural rules of the respective courts in the various northern states, the magistrate court laws of the respective northern states, subject matter specific criminal laws, as well as offender type specific criminal laws such as the Children and Young Persons Acts and laws of the respective states. For southern Nigeria, we have the 1999 Constitution as amended, the Administration of Criminal Justice Law if the ACJA has been domesticated, or the Criminal Procedure Law (CPL) if the ACJA hasn't been domesticated, procedural rules of the respective courts in the various southern states, magistrate court laws of the respective states, subject matter specific criminal laws, and offender type specific criminal laws such as the Children and Young Persons laws of the respective states. And for all of Nigeria, we have the 1999 Constitution as amended, the Armed Forces Act, the Federal High Court Act and Rules, the Court of Appeal Act and Rules, the Supreme Court Act and Rules, as well as the ACJA. Let's take a look at the laws and the rules applicable to criminal litigation in various courts in Nigeria. Federal courts first. In the federal court, we have the 1999 Constitution as amended, the statutes establishing the courts, such as the Federal High Court Act, the Court of Appeal Act, the Supreme Court Acts, etc. You also have the procedural rules guiding the operations of the respective federal courts. For state courts in northern Nigeria, we have the 1999 Constitution as amended, the procedural rules guiding the operations of the respective northern courts, either the ACJL if domesticated, or the CPCL if the ACJA has not been domesticated, the magistrate court laws of those states, and finally, for the state courts in southern Nigeria, we have the 1999 Constitution as amended, the procedural rules guiding the operation of the respective southern states, either the ACJL if the state has domesticated the same, or the CPL if the ACJA wasn't domesticated, and then the magistrate court laws of those states. So we now have our take-home assignment, comparing and contrasting the laws and rules applicable to various courts in Nigeria. Basically, there are a minimum of two laws that are applicable to criminal legislation or litigation in the various courts on the screen. The question is, what two laws regulate procedure at the Federal High Court? What two laws regulate procedure at the AFCT High Court? What two laws regulate procedure at the various state high courts? What two laws regulate procedure at magistrate courts? What two laws regulate procedure at a court martial? So that's our take-home assignment. If you have followed the lecture so far, it should not be an impossible task to fulfill. With that, we are done with part 2 of this lecture.